will not be entitled to same benefit as would contrary to legal principles. So, however, in consideration of disability, these candidates will be permitted to continue and will receive wages until fresh selection. Next, paragraph 49. These disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required with age relaxation and other concessions. But if your lordship,
Next sentence.
particularly other candidates.
This is similarly indicates that
Tainted cannot appear, whether disabled label is immaterial.
That whatever you know, we have no other.
Keep the object.
One request that this issue
of the disabled candidates
for
is provide
2 minutes. Item number
one request that this 10 marks may not be
Because
real.
all parties are before the High Court and the High Court.
again and again before the High Court to bring in the tainted candidate. We do not understand why.
High Court is not. High Court is not listening.
Our interpretation, we have done it.
All these cases we are going to close.
At least this candidate, Professor Emma, should get the
Well, let
7
the
years
High Court
benefit
decide.
Cannot be
All issues you raise,
because examination is over there.
all issues you can raise before.
Worships have already adjudicated.
We are not going to have parallel proceedings.
I have one.
He was appointed with due process of law.
Prior experience,
Sorry,
the High Court by
Well,
looking
that
at
High Court
prior
will decide.
experience again.
that is a different issue. It does not come
You have not
Yes.
judgment.
High Court is considering the constitutional validity, not the same thing.
One of the so far as
We are closing all matters.
here we were.
Lordship, kindly all these
You are the villain of the piece.
One conclusion I have made.
don't allow to High Court additional series, Lordship.
There was a findings division bench regarding the teaching experience which has been given, that has been sanctioned by the division bench. Then one Orunima Pal was the unsuccessful candidate.
She was a tainted candidate.
No.
No, why the School Service Commission is interested in this matter?
Opposing everything against her.
Arunima Paul, I dismissed. I dismissed.
No.
Yes.
Exactly.
Why the SSC is so much concerned?
Exactly, I'm saying that. Kindly just
Lordship,
hear me for 2 minutes.
6.25, I take
Orunima
untimed Lordship from this.
who was unsuccessful in 2016 selection process.
But she was not even selected.
Yes.
Not been selected. Now, in 2025, he challenged that. Against that.
Perhaps you have changed
What
it.
is that? No. Please, kindly allow. No.
No, the High Court is considering the constitutionality of the rules.
Kindly,
Let the High Court decide the matter.
kindly just hear me,
You know
Milord.
the decibel levels work at the Supreme Court.
Milord, kindly just hear me, Milord. Just 2 minutes.
Yes.
Without any interruption. Then your lordship will dismiss my contents. I have no difficulty.
2 minutes, start
2
now.
minutes, just 2 minutes.
Yes.
Unsuccessful. 2016, 2025, they sat. They became again unsuccessful. They challenged the division bench judgment, where the division bench upheld the provisions of the teaching experience, right? And against that, SLP has been filed. Your lordship dismissed that. Therefore, those who are saying
You will
about
need to also see what the locus of that person was.
no.
We did not
Yes.
say anything on the merits of the matter.
So,
So mere dismissal of the matter does not mean that all principles in that judgment have been upheld.
Yes.
Because therefore, all of you go back to the High Court.
Lordships are not deciding the para 47 issue. We are on the this category. We are not on the
7.
para 47.
7 you've been allowed to join, is it?
No. I have a small request.
They can argue before the High Court.
Applications are different. Let that not be disposed of by this order in 90s.
47 is people who are wanting
One
to
set
go back
is
to
not
their earlier job.
joined already,
Yes,
one
yes.
removed and then came back for this, my lord. Your lordship permitted them to go back to their respective departments.
Within the state of West Bengal.
Yes. Now, my lord, we represent about 30-40 people, my lord. What has happened with them is simultaneously after they joined in this, my lord, simultaneously they got appointment orders from two other or one other different department of the West Bengal itself. Since they have joined and there was no case pending at that point of time, they could not join the other department, but they continued
that's
here.
that's going
But
beyond 40.
now today I am left with no remedy. We are all
Yes,
age part, age part.
kind of candidate.
We're all
47
age
does
part
not cover
also.
that situation where
Because we
Look,
want
there are
to
the offer of another job which you never joined.
Is there are vacancies?
We only permitted you to go back to the job that you left.
Plus,
Come
we
into
are
this.
placed similarly.
There are
Placed
similarly.
similarly.
Go back to the high
Similarly, Lordship,
How you offer, you
can go
seven,
back to the high
seven
court.
years
Allow us to
benefit,
go
7
back to
years
the
job
High Court.
benefit.
Let them withdraw here.
Devla, they
Applications can
want
be
to
Item
amended
number
by the High Court.
Let
Let me just withdraw here and go back to the High Court.
and again.
So far
That
as the
judgment should not
protection
come
Lordship
to the
has given, that should be made.
you won't say anything, whatever you wish to say before
Let
the
us
High
please
Court.
withdraw these
Yes.
plans. On High Court.
Months,
On High Court.
19.15,
19.15, I'll withdraw.
19 point,
15 and 16.
19.15,
Liberty.
19.1.
All of us will say that, Lord, same order.
Moana, which one do you want?
19.9 to 19.23, I appeal.
19.9,
9 to 19.
all of them.
Yes.
All
All
of
of
them.
them.
Them, you know,
This was
with liberty, you know,
liberty to
approach the High Court,
Approach the High
for the same relief.
for seeking redressal.
Also,
One more thing, not the findings in the,
accordance with law.
and the judgment of the court should not
Then-
be in the way.
Yes.
We won't say anything.
19.1, 19.1,
No.
19.8 also.
19.1,
All same one. 19.15 and 16.
19.1,
15 and 19.16.
19.38. 19.38.
So good, it can't stop. So you can try to fight it, but that music don't stop.
Nineteen point two
Just one
seven.
minute. There is one clarification when it would be needed because now after the result, they have published a list only by name. And the list of tainted candidates are there. Now it is very difficult to find out.
High Court is seized of that.
Your Lordship, we just
Once the High Court is seized of that issue,
Detail.
then
May I make one suggestion on the High Court? On the High Court,
we'll make a
Your Lordship, in
clarification.
November
with that.
23, had
19.27.
Yes, Ms. Makija.
Something very important to say. Lordships have said that 31st December,
December tak we
the
can.
exercise must finish, your Lordships. Now, unfortunately, I've just given this list. There are more than 70 matters which have been filed in the High
That
Court.
of course we'll have to.
Lordships, let me finish. Where different aspects, there's hair splitting, different aspects are being challenged. I have no problems in the matters remaining pending. All that I'm saying to your Lordships is that matters can go on, but let no interim orders be passed. till-
yes.
Court hasn't passed any interim order. Why is that
Allow
mentioned?
continue to the.
Court hasn't passed any interim order. Honorable Supreme Court cannot be.
The tainted candidates have gotten through, they can't be
Tainted.
Yes.
Right, no tainted candidate.
No.
Any other matters which need to be withdrawn,
Suggestion on the High Court. When we will
withdrawal matters anymore.
Now we will get decimal more.
19.25, Lordship, 19.25.
Now we will decimal.
If you want to withdraw, say so.
I want to pursue the matter.
No, you're not pursuing it here.
Under para 47 of the law.
Para 47 orders have already been implemented.
I'm working in the autonomous body in Kendriya Vidyalaya Sansthan. They are not.
Where? Where are you?
Bengal.
Why is he not returned to his?
No, we have given, everyone we have
He is
given.
in Kendriya Vidyalaya.
Central government is not our
Government.
Vidyalaya Central.
Central government perhaps is not a party to it.
Can be allowed.
We have only said the government, we not the state government. State government and autonomous body. Autonomous body, Kendriya Vidyalaya is a central government organization. It's not an autonomous body. It is not an autonomous body.
Under
Plus, can we
on going back to the High Court, may I make a suggestion, my lords? Your lordships in November 23, when your
That's a
lordships
different
have
issue.
the order.
You'll have to go back to
There are a
the.
lot of matters that your lordships can see. There are a lot of matters, a lot of issues. Your lordships want to send everything back to the High Court. No, very well. Because in November 23, when my lords had passed a similar order at the interim stage, my lords had said go before division bench and hear it expeditiously. My lords may pass a similar order this time, so the matter can be heard finally.
No, no, no.
Just one prayer, my lord.
That's all. Now let us dictate the order.
Pass the order.
The order.
Yes.
Your Lordship, will your Lordship be, your
Teacher should
your Lordship be
continue,
pleased to
my
take up the intervention applications in item
You should
19?
be permitted to continue, my lord, till the time of the case.
No further order, no further order. High Court will please
All issues to address.
be heard by the High Court.
Yes.
Will your Lordship be pleased to take up the intervention applications, your Lordship, in item
Go
19?
before the High Court. By this, because we then the state government and bodies which come under the state government.
No, just 1 minute, my lord.
High Court
High Court, I go there. But we will approach the High Court in 2 weeks' time. Kindly protect us.
Your Lordship,
2 weeks, kindly give us protection.
Your Lordship,
Approach the High Court.
will your Lordship be pleased to take up the intervention applications in item 19, your Lordship?
88 of 2025 has already been entertained by a learned judge of the Calcutta High Court, and various issues were flagged by the learned judge in the order. What is the date of this order?
Lordship, there are various orders, your Lordship.
19/11/2025. Wherein
Yes.
the matters pending before this court as on date were kept. The matters on.
My lord, and
Matters on file before this court as on date were kept pending. You got the sentence. The matters on the file of this court as on date were kept pending only for the purpose of verifying as to whether or not the directions of this court in the judgment dated 3/4/2025 in state of West Bengal versus Baisakhi were being implemented scrupulously. As we now find that a learned judge of the Calcutta High Court has taken up that issue, we are of the opinion that it would be appropriate that the High Court, being the court of the first instance, undertakes this exercise instead of this court.
Yes.
It would be open to all the petitioners, public applicants before this court, to approach the High Court for redressal of their grievances
Yes, ma'am.
in accordance with law.
However, the selection process which is underway will not be stopped, your Lordships.
We will not say anything.
That-
We will not-
Nothing.
The High Court
What sort of prayer is made?
fix the time-
Direction, that
We have fixed the time frame. As and when they come with an extension petition, then you can open.
I should have,
Yes.
you can stop to any selection.
I'm deeply obliged.
Will your Lordship be kind enough to take up the intervention applications, your Lordship, impeachment applications in item
already
19?
got an order.
Through. None of the tainted candidates are permitted to slip through
11th November, 12th November.
during the fresh selection, be it on one pretext or the other. The High Court shall also ensure that the list of tainted candidates is placed in the public domain
Yes. Yes.
with full details, with full details,
Grateful, grateful.
so as to ensure that
And
this does not
unselected
happen.
candidate should get the benefit of 7 years, Lordship.
Your Lordships, it will be Lordships to say that the process should not be stopped.
When it comes to seek to read more into certain aspects of the judgment dated 3/4/2025, would also be at liberty to raise such hermeneutics, HERMENEUTICS, before the High Court.
Your Lordships said that. Your Lordships have referred to an earlier order, the single judge's order. Well, Lords, against that, there are several other orders. There is an order of 12th of November. Your Lordships in the first paragraph.
19th November.
7th November.
11th November.
I want those also.
Yes, but also
Same learned judge. 11th November, 12th November, 19th November.
11th November, 12th.
And add this 20th order,
20th
Lordship.
November.
In those orders also issues are being flagged.
All issues and
Both them are accepted.
Well, 7th, 12th and 19th.
7th,
11th,
12th.
7th, 11th, 12th and 19th.
And the judge is hearing all the issues. let it-
It's of successful candidates also so that it can be compared, right?
7, 11, 12,
Compare this.
Compare what?
7, 11,
Those who have succeeded in the exam.
19.
and
Why
those
would we want the untainted candidates to be looked at?
who are
That's unnecessary.
able to know
Unless the High Court is now on a time frame, they have to complete it as.
The matter is fixed on 28.
Lordship, be kind enough to take up the intervention applications, Your Lordship.
And the applications
Yes.
are disposed of in the.
Keep low blind. Keep low blind. Keep low blind.
Consider saying uninfluenced in our future.
Now, this will ultimately bring empathy to
Uninfluenced
questions.
by
High Court can look into it. Matters uninfluenced by.
Yes.
Any of the observations on merits made by this court in the earlier orders.
One more.
And one more line, Lordship, kindly add one more line.
One whole section
Untainted
is now get out of.
We've already discussed, withdrawn various matters. You want to withdraw?
Lordship, these are the cancer patients. We have aimed a similar relief orders on humanitarian
Oh,
grounds.
that's
That was refused by the court.
Cancer patients and all that. We only said dealt with physically disabled cancer.
Lordship, the Soma Das.
Click to Ahmad,
Soma Das was a blind
Lordship, it was
Blind, that's right.
cancer and blind. She was a physically
The
disabled.
court categorically held Soma Das case will not be applicable.
She was a physically disabled candidate too. She might have had cancer also, but she was within our scope only as a physically disabled candidate.
Because the matter is listed day after, this order may be uploaded today, it's listed day
We
after.
uploaded today.
Yeah, very great.
So far as
Keep low blind.
Lordship, we
Sorry, go before the High Court, please.
Extremely obliged to the honorable court.
Lordship, if Your Lordship may be kind enough, Your Lordship, in item 19.
Go before the High Court.
Now vacate
Already given
place,
that.
space for others.
My lords, your court will now empty out members.
Yes.
Lordship, insofar as.
Your Lordship, in item 19, the intervention applications.
So the first item, we were permitted to participate on account of the old qualification 45. Lordship may clarify that
You've already challenged those rules.
No. We repelled by the High Court. It was, we succeeded in an appeal and then we are here, my lords.
The High Court shall also be mindful of the fact that the
21st August.
untainted candidates during the past selection were allowed to sit for the exams,
In terms of this court.
for the selections afresh, to be held afresh, and their candidature cannot be adversely affected
Grateful.
by application of the new rules which.
Grateful.
and one more line, Lordship, I want
To the untainted candidates would be.
You can't. Untainted candidates,
Lordship.
they have faced examinations.
These untainted candidates will get the benefit of 7 years.
To weed them out.
No. Why? Some
They have appointed.
If I say
Therefore, Lordship may retain this matter.
You come up with these new rules and you try it.
And they will permanent in their job.
Because of.
Kindly add
because
this
of
one
our order,
Kind, yes.
Item 19 may be retained, my lords, because of
And
this.
21st also, my
Kind,
lords.
not this anywhere.
In item number 19.25.
We have given
Click to Ahmad.
10 marks for experience.
So you'll be giving them all 10.
All.
All the teachers, untainted teachers will be.
We are all untainted.
At what stage?
Will you be giving 10 marks to all?
10 marks if he has
Waited.
for first year, 2 marks. If they completed 5 years, 10 marks.
Well, 2019 were. All of them have 5 years.
Yes, now we want.
Yes,
Now that is challenge.
That is the reason why we asked them, you are benefited by this.
No.
Yes. We want gold.
Kindly just get Millard. Decibel is that side higher.
For once.
Now
You have the microphone.
Now what has happened?
Can never.
What has happened in the written examination? Some of the untainted teachers have secured only 26 and 30 marks.
And 7.
So they get these 10 marks though.
Even they have added 10 marks. Even educational qualification 10 marks. Even in that case,
If
they
they
are
are
less.
not selected, they are not.
They are less than fresh candidates. Yes, marks are less than fresh candidates.
We are not.
No. Therefore, people also say that all untainted teachers have to be allowed. Then it is.
We have not said they will be allowed. We
They
said
cannot
that you
be
will not
disqualified.
Yes.
adversely affect them with
Their
the
previous
application of
experience
this.
should be counted, Lord.
This 50%, 45% you cannot apply.
Yes, yes.
Too much. This is too wide. Because freshers are also coming within this group. अरे भाई, what
सर आपको समझ में नहीं आया मेरे को।
but this new rules will be applied also to the freshers? No.
New rules will not be. See,
To me,
yes,
freshers and
when we asked you to undertake the selection of fresh, we did not contemplate that we will add new vacancies and bring in fresh.
Yes.
The intention was that you would hold a fresh selection for these untainted.
Yes,
You
but
enlarged the scope of
Lordship,
that. You brought
Lordship,
in
there
fresh
are
vacancies.
untainted
You brought in
candidates,
fresh
Lordship.
candidates. So
Their
you asked
previous
for this
benefit
rubbish.
should be
On
added,
top of that,
Lordship.
you bring in new rules. Then, once you bring in new rules, it can only apply to new selectors. It cannot
High Court
apply to
is
these people
pending.
whose selection has been set aside and they've been given another go.
But your
That doesn't mean that you apply the new rules to them.
But your lordships have said to appear in the
Now, let this matters be now argued before the High Court. Why he is
selection
wasting?
would start. Fresh
Giving of
selection means
10
also
marks to
examination.
untainted candidate,
If an
that is a very
examination, a selected candidate, the untainted
When
candidate
did you ask us for permission to frame new rules and apply it to the
Yes,
untainted candidates?
to create all trouble.
Did you ask for that?
Well, they have. We have.
You've done that. So far as these untainted candidates are concerned, their candidature shall not be adversely affected by application of these new rules.
Well, then in that case,
deeply obliged.
that
Greatly obliged. Greatly obliged.
candidates who have secured lesser marks than the fresh
That selection, whatever you wish
That
to do, you do that.
is go by the rules. Go by the rules. It doesn't go by the interpretation.
clarify that.
That is all. That is all.
As such,
That's all, that's all.
Test after 10 years.
That's all.
Yes.
That's
Lordship, in item
let
19,
the
Lordship.
High Court is considering the matter. Let the High Court do it.
Nothing. We've said that the untainted candidates.
Lordship, kindly add one line, Lordship, in order. Their previous.
My lord will not.
Lordship, item 19, Lordship.
End this now.
Your Lordship, I have an intervention application, Lordship, in item 19.
About it, and all probably come back to me.
But we all want to be heard by your lordship, my lords, always.
No.
Always want to be heard.
We've not said anything about that. Why should she say? You sensitize the High Court that they are great.
I am ready to whatever your lordship says. If your lordship declares that all tainted candidates will be taken into the employment.
Tainted candidate.
Untainted.
You said tainted.
Well, whatever is there in the order. No further clarification is necessary.
It should be separate hearing, Lordship. Untainted candidate.
No.
You didn't say untainted.
Untainted. If your lordship desire that.
Well, SSC is much interested to see that the corruption again gaps.
In a competition, they are lesser marks.
Next
In
matter.
fact, not they should have held a separate selection for us. They didn't do it actually.
Take place.
Next matter.
Your Lordship, in item.
Because we are grateful, my lords.
Next matter. Yes.
Could the appearance be given physically?
Yes.
Grateful. 7 maybe. Grateful.
19.37 also. 0.38. 38. Oh, he doesn't want to put this piece in. 37. 27.
24 is of the same one.
24, you want to withdraw?
No, it's the same one.
Same one.
24.
24, same one.
20. 20 council has come in or still battling at the door?
What is empty now? Sir?
Yes.
And no more sweats, Your Lord.
But then what Mr. Gopal Subramaniam is equal to all of us. Anything
Now you will be elegantly addressed by Mr. Subramaniam, my lords.
That's why it said one is equal to all.
And the football rabble-rousers are going to leave, my lords.
Sorry?
The football rabble-rousers. My lords, we gave you the atmosphere of Mohan Bagan versus Mohammedan Spotted. It was like you were in West Bengal. Grateful, my lords.
Yes, 20. Yes.
Please, your lordships. Well, the issue is a short one, as far as the,
It wouldn't be short with you appearing, Mr. Subramanian.
not I try to be as concise as possible.
There are cross appeals, my lord.
Well,
Yes.
One issue, my lord, they have succeeded on the other issue, my lord, we have succeeded, my lord.
Yeah.
Lord, there are two appeals.
Yes.
That is Civil Appeal 9701
Yes.
of 2025. Lord, I beg to appear for the appellant in that appeal.
Yes.
না না ইনজুরি নয়, এই জুটি সঠিক নয়, এটা হলো তো পারফেক্ট জুটি। যেমন বিড়লা হোয়াইট পুট্টি আর অনলি বিড়লা হোয়াইট প্রাইমারের জুটি। পুট্টি আর প্রাইমার হোয়াইটেস্ট তো দেয়ালগুলো ব্রাইটেস্ট।
On behalf of the very same party.
Respondent.
Yes.
For the respondent. Yes.
Lord, this present appeal, my lord, is directed against the judgment of the National Company Law Appellate Tribunal of the 24th of January 2024. And in substance, my lord, it affirms the order passed by the National Company Law Tribunal, which rejected, my lord, the petition under Section 7 of the Insolvency Code.
Lord, one small interjection, if you don't mind. Lord, I respectfully submit, my lord, the question which is answered against us, my lord. Just give me a second. If, my lord, we address your lordship on that point, my lord, the issue, my lord, which is decided against them will become irrelevant. So in case your lordships would like to hear that point first, I leave it to your lordships, my lord.
Lord, may I just set up my facts, then I'll be in your lordship's hands. Let me lay out the facts, and then after that, Lord, your lordships may take over. Lord, let me straight away bring to your lordship's attention what happened in this case. My lord, there are two entities who are involved in this matter. One of them, my lord, is called ESL, and the other, my lord, is ECL. I'm just, my lord, using an acronym for the purpose of convenience.
Yes.
My lord, ESL, if your lordships will see, it has a slightly longer name.
Electro steels.
That's right, my lord. Your lordships will notice that it is Electro Steels Limited, ESL, which is the principal borrower.
Yes.
Electro Steel Castings Limited is, my lord, the party whom I am pursuing.
Yes.
And according to me, my lord, it is a guarantor. And there exists, my lord, a contract of guarantee, which can be subjected to the regime in the IBC. So, my lord, everything really revolves around the question whether there is such a relationship as a guarantor, whether a contract of guarantee is discernible, and if it is so, then, my lord, logically, the applications are maintainable. The NCLT, my lord, came to the conclusion, after examining the various documents in question, that a contract of guarantee was not made out, and therefore the application was incompetent. My lord, in the appeal before the National Company Law Appellate Tribunal, the Appellate Tribunal, my lord, concurs with that for slightly different reasons, but, my lord, reverses a finding and says that, in fact, there is no extinguishment of liability on account of the resolution plan, because, my lord, various reservations are contained in a resolution plan, that this does not in any way impact or impinge upon the liability of a guarantor, liability towards a guarantor. But Lord, this is just the broad view which I wanted to place for your lordship's consideration. Yes. Now, my lord, let me place some documents, because ultimately, my lord, under Section 126 of the Contract Act, we have to examine, my lord, what is the law and how has it been defined. My lord, I must say, there is a distinction which is often drawn between guarantees which are called on-demand guarantees, like, my lord, bank guarantees, which on site you are meant to pay the money which is guaranteed. And you also have, my lord, what are called guarantees which really are intended to ensure the performance of an obligation. these, my lord, are colloquially called in English judgments as to see guarantees. That is, you ensure the performance of an obligation on whose behalf you are an obligor. So, my lord, the expression obligor or the word guarantor, my lord, these are all words. But ultimately, your lordships would have to see that is there an element of undertaking? Is there an element of voluntariness that in the event that there is a default, then this person will do what is required to remedy the situation, that that person will not be in default. So, my lord, if the extent, if I may say so, of assistance or obligation which is undertaken by the obligor is coextensive with what was the obligation under the contract of the principal borrower, then, my lord, it amounts to a guarantee. Now, my lord, this is the real question which arises. My lord, there is a recent pronouncement of this court. There was a question, my lord, again under the IBC. There, my lord, it was styled as a deed of hypothecation. And the court examined the question. It may be christened as a deed of hypothecation, but if it has the constituent elements of Section 126, we will not hesitate to treat it as a contract of guarantee. So, my lord, it appears from, I'm just...
हाँ बोल बेटा करण। क्या? जिंदगी की रोज की दौड़ में हम अक्सर चीजें भूल जाते हैं।
अंकल!
पर अच्छा लगता है जब कोई आपका ख्याल रखता है, जैसे कि आरबीआई ख्याल रखता है आपके अनक्लेम डिपॉजिट्स का।
अनक्लेम डिपॉजिट मतलब?
वो बैंक खाते।
Then, my lord, notwithstanding, shall we say, pleading, notwithstanding for the matter of fact, my lord, something said which is inconsistent with it may not necessarily decide the issue. It is, my lord, preponderant evidence of the presence of these elements which will lead to the existence of a contract of guarantee. Now, my lord, that's the burden which I have to take for the purpose of succeeding in this appeal. Yes. So, my lord, may I take your lordships to the various documents? Yes. Because I will take them in a chronological manner, yes, and your lordships will then come to a view whether they militate against the existence of a guarantee. Well, the first document is Annexure A2, which is the sanction letter, which your lordships will find is in volume 1, your lordships printed page 204.
Yes.
So, my lord, I'm using a soft copy, but I have also noted down in the notebook. My lord,
we are old timers. We use hard copies.
That might be.
So I just add, my lord. My friend said he laid down the facts.
Oh, Mr. Mehta has vanished.
No, he'll be here. He'll be here. My lord, it is better to first note who was the debtor.
Yes.
What was the resolution plan? What did he say about the debt? Does the debt survive after the resolution plan? Because you will go to a guarantee only, my lord, if the debt survives. So it is one of our points that once the debt is fully discharged, extinguished, there's no question whether you have or you don't have. So it may be better if you first start, my lord, with the fact as to who is the debtor. My friend is an assignee of a creditor who was a part of the plan. It's better to probably look at those factors.
May I say, my lord, each one has his own rhythm.
It's okay.
And my learned friend may take it. I will
We
certainly...
are aware of those facts, Mr.
No, otherwise,
you
are going straight to a guarantee without seeing what the debt is.
We are aware of the fact that he's an assignee of
So, yeah.
SREI.
Nothing is going to be missed. I assure my friend that nothing will be missed.
SREI is a short form, or the name itself is SREI?
No, my lord, it is got a slight name. SREI Infrastructure Finance Limited.
But SREI is a name by
Yes, yes, that's the name.
I thought it was a short form for something else.
So, we are also in IBC.
They are also in IBC.
Yeah.
My instructing attorney says that they have fortunately come out of the IBC.
Come out of it. Yes.
They were in IBC.
Now, my lord, let me take the first document. That is page 204. This is, my lord, the foundational document, which is the sanction letter.
Yes.
And this, my lord, your lordships will notice, is addressed to the principal borrower, Electro Steels Limited.
Yes.
We write with reference to your aforementioned proposal and subsequent discussions on the subject. We are glad to convey our final approval for a rupee term loan for the above, as per the terms and conditions set out in Annexure 1, which are indicative and not exhaustive. The above facility is also subject to the terms and conditions to be enshrined in the loan agreement and other transaction documents, agreements, financing documents to be executed at a later date. Well, the reason why I'm reading this para is that as an assignee, well, ultimately I was an assignee. The assignee, in fact, assignment took place after the sanction of the resolution plan.
Yes.
And according to me, Malot, I'm a valid assignee and I have to derive my rights in terms of the underlying documents. Now, Malot, after this, if your lordships would be good enough to see further, Malot, at the bottom of this, there's a reference at printed page 207 to two annexures, Annexure 1 and Annexure 207.
Yes.
Then, Malot, we now look at the annexure, which is the term sheet. Your lordships will find the term sheet printed page 208. Facility amount, rupee loan commitment, rupees 500 crores only. Your lordships will find that.
Yes.
That is, Malot, the facility which has been given by this sanction letter.
Right.
Thereafter, if your lordships will now come to the next, please come to printed page, Malot, 222.
22. Yes.
Your lordships will notice on the left-hand column, promoters, sponsors, partners, undertaking. Now, my lord, I submit with respect that as far as ECL is concerned, my lord, the person whom I am pursuing as a guarantor actually is a promoter within the definition, my lord. And this promoter, sponsors, partners shall furnish an undertaking that the promoter, sponsor shall not without the prior written approval of SREI transfer, assign, dispose of, or pledge, charge or create any lien, or in any way encumber their existing or future shareholdings in the borrower in favor of any person or company or any other entity, except as disclosed prior to the date of first disbursement. To arrange for additional funds, now, my lord, please mark item 2. To arrange for additional funds in a form and manner satisfactory to SREI in case of any cost overrun, if any. Number 3, to arrange for the infusion of funds in a form and manner acceptable to SREI at the end of each financial year to comply with the financial covenants in case of breach of such financial covenant. Now, my lord, according to us, this is a substantial obligation, and your lordships will find this gets strengthened and strengthened as we go along. Now, my lord, the next document which I want to place for your lordship's kind consideration is the document which is dated. My lord, this is the sanction letter. There is another document which your lordships will find is at printed page.
Do you ask for any acknowledgement of these terms? Or
no, my lord, this is what they wrote. This is the first. After this, your lordship.
This is Sray's letter to electricity.
That's right. Now,
so do you,
this is
do you
what
also ask for some
it has been
acknowledgement from them?
Yes, yes. Not only that. Now, please kindly see, there are further agreements. Yes. Let me now show, my lord. Please come to printed page 248.
Yes. Okay.
This document, my lord, begins at 247.
Yes.
Please see. This is in pursuance of our sanction letter dated 26th of July 2011, bearing reference number so-and-so, sanction letter wherein we had conveyed our approval for extending to you
Do you also have a list of dates or
I have.
or
I have. I'll hand them over. Yes, certainly. Just get out. List the one. Okay. Get the list. We'll just note. Please see, my lord, at page 2, printed page 247.
Yes.
This is a second letter of the same date.
Yes.
And please see, we would like to inform you that after conducting due diligence of the project and further discussions with you, in addition to the terms and conditions set out in the sanction letter, we shall require you to provide such additional security as stipulated hereunder. And your lordships will notice at the bottom of that page, we would like to further confirm that as on date, as per the terms of the sanction letter and other financing documents, no personal guarantee from Mr. Kejriwal or corporate guarantee from Electro Steel Castings Limited is required for securing the facility. Now, Mullah, this sentence, this one sentence is being, Mullah, actually used, repeatedly relied upon to say that there is no corporate guarantee because of this sentence. But Mullah, really, if one reads the tense of that sentence, it says this as on date, that is as on that date, as per the terms of the sanction letter and other financing documents, no personal guarantee from Mr. Kejriwal is required.
Who is he?
Mullah, he happens to be the promoter and managing director of the group, Mullah. This gentleman, Mr. Kejriwal. Or corporate guarantee from Electro Steel Castings is required for securing the facility. So, Mullah, it was not a condition precedent on that date. Now, we will see how things develop thereafter to determine whether there is a guarantee. As on that date, it was not required. That's fair. But Mullah, this does not in any way, if I may say so, impinge upon documents which are executed later, actions and transactions which actually suggest that Mullah, ECL undertook its obligations like a guarantor. Now, Mullah, this is the document. Now, please see, your lordships will now come to the loan agreement itself, which is at printed page, Mullah, 250.
Second volume.
And in this, if your lordships will notice, this is the loan agreement. In the loan agreement, Mullah, the parties are.
Yeah.
It's still, I suppose, Mullah, the first volume.
Sorry? It's the second volume.
I think.
Rupee loan agreement.
Yes.
Yeah.
This, Mullah, is the agreement.
Yeah.
This is dated, as your lordships will see, this is also dated 26th of July, 2011. And please see, Mullah, the parties are SREI and Electro Steels. Then please now come, Mullah, straight away, as your lordships will see, after all the terms are properly defined, your lordships may kindly come to page, I'll just give Mullah the printed page. This would be, yes, 386, Mullah. Yes, I have. 386.
Yes.
Mullah, on this day, your lordships may also notice that ECL was having the largest percentage of shares in the principal debtor. And please now, principal borrower, promoters' undertakings. Does your lordship get that?
Yes.
At printed page 386. The promoter shall furnish an undertaking. Now, my lord, we have moved forward. Shall furnish an undertaking. The
What is the date of this agreement?
Well, this is also 26/11/2011.
Same day.
Yes,
Same day.
same day. 26th of July 2011.
So everything happens on the same day.
Yes, my lord.
Yes.
The promoter shall furnish an undertaking that the promoter's sponsor shall not, without the prior written approval of SREI, transfer, assign, dispose of, or pledge, or create any lien, or in any way encumber their existing or future shareholdings in the borrower in favor of any person or company or any other entity, except as disclosed in the disclosure letter. Now, my lord, this first condition, which imposes a restriction upon your ability to deal with the shares in the borrower entity,
is indeed a restriction. But this restriction, my lord, is only to indicate that there is a constituent obligation which is placed upon the guarantor, my lord, subject to his being called a guarantor, to arrange for additional funds in a form and manner satisfactory to SREI in case of any cost overrun and a gap in means of financing, if any. 3, to arrange for the infusion of funds in a form and manner acceptable to SREI at the end of each financial year to comply with the financial covenants in case of breach of such financial covenant. This, my lord, is the obligation. After this, if your lordships will kindly go over to, my lord, please see printed page. Let me show, my lord, that is clause 6.3.1. That would be, my lord, at printed page 335.
330.
Yes, I just needed to show that, my lord. That's where the obligation lies.
Who signs this document though?
I'll just indicate, my lord. My lord, only the borrower and Shray.
Where do we find that?
My lord, we'll find that, your lordships will find. At page 466, my lord, printed page 466. It's just 416. 416, my lord, 416.
416.
Yes, at the bottom, your lordships.
There's no signatures there. It doesn't. 416 has both ESL as well as.
Yes, yes, my lord. Yes.
Is that part of this agreement or is that a separate document?
That's a separate document, but I'll give you the signature page, my lord, of the other one. 378, my lord. 378.
Signed and accepted.
Common seal of Electro Steels Limited, pursuant to the board of directors.
Borrower has crossed.
Yes.
Very good. Page 3.
In the presence of so and so, authorized signatory of the borrower who has signed these.
We'll continue after lunch.
Certainly, Lord.
But we'll be a little late perhaps because we have a full court meeting today. We can't tell you how long we'll be.
But
you can have a cup of coffee, extra cup of coffee before you come back.
Lord, may I please mention item number 3, my lord. We want to withdraw it, my lord. Item number 3.
Number 3. 3 is passed over.
No, my lord.
Then?
The argument was heard, my lord.
And then
Senior has asked.
dismissed.
Yes, ma'am.
We want to withdraw it after the event.
Item 3.
3.
Dismiss.
Right. He doesn't want the trial to be expedited.
আরে করণ শর্মাজির ছেলের থেকে কিছু শেখো নাসাতে রকেট সায়েন্টিস্ট ইয়েস এমন কোনো কোয়েশ্চেন নেই যার আনসার ওর জানা নেই
ও রিয়েলি তাহলে তো এটাও জানো যে প্রাণ পোটাটা চিপস না বিস্কিট
বল বল
এটা
পারবে
চিপস না বিস্কিট। কি এটা? কেন নাসাতে শেখায়নি? বাবা, বাছাই করা আলু আর স্পাইসি সিজনিং এ প্রাণ পোটাটা চিপস নাকি বিস্কিট খেয়ে বুঝে নাও।